Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining me. Today we're going to be talking about Chapter 7 bankruptcy. Once again, my co-host, as always, is Jesse Barrientos. Jesse, welcome to the show.
Thank you, Dave.
How are you doing today?
Excellent. How about yourself?
I'm doing well.
Great.
Jesse, whether things are going well in the country or whether they're going terrible, whether people are rising or falling, the one constant is bankruptcy. So we're going to talk about Chapter 7 bankruptcy because it's an important feature provided under the federal government's constitution, the right to file a bankruptcy and either get a fresh start or reorganize. So I want to talk to you first about Chapter 7 specifically on this show, starting with what is Chapter 7 bankruptcy?
Chapter 7 is essentially a complete discharge for your dischargeable debts. And I think we'll probably talk in a little bit on which kind of debts are not dischargeable. Unfortunately, our mortgage crisis hit everybody, so we're all kind of in the same boat. There's a lot of people, more than ever before, and they're just rolling in debt. And I have to tell you that, the pressures of having not only this debt heaped upon your shoulders, but also having to be able to provide for your family and getting harassed by the creditors. And make no mistake, we have the Fair Debt Collection Act, but most of those people, a lot of them, do not follow what those rules are.
Interesting. When would somebody want to file a Chapter 7 bankruptcy as opposed to not filing at all? What's the reason why someone would file a Chapter 7?
I guess there are a lot of different reasons. One would be, for example, if somebody filed a lawsuit against you, and once somebody gets a judgment, and I think we've talked about that in one of our programs, we've gone through the small claims process and some other processes, but once a creditor obtains a judgment, then they do what they call supplementary proceedings. That includes the possibility of attaching a lien to your wages, wage garnishment, or of attaching to your bank account or any other assets that you may have. So if I'm struggling check to check, to try to pay my family, and I know, I'm going to get hit, and it's going to be at least 15% taken out of my paycheck. I'm not going to be able to make ends meet here, and so, that would be a good idea. That would be a reason why people would file a Chapter 7, but I'm not going to do it for $1,500, if that's the extent of my debt. There has to be some kind of threshold. What that is, it's up to each individual, but I think perhaps that, it might be a little bit more than that.
Why not allow that creditor just to take the 15% on an ongoing basis and not file?
Well, you are allowed to discharge that debt, and generally, people have a lot of other debt as well. And most of the time, they're lined up. The way that it works with the garnishments is the first one through the door, that's the first one until that's satisfied, and then the next one is right behind that, stacked up, and a lot of times that's what happens. So you can never really get ahead.
So it's not just one creditor, there's usually a series of creditors. There might be past due medical bills, past due utilities, maybe a foreclosure, repossession in their history.
Exactly, or could also be a car accident, because if for example, you didn't have insurance, and of course, it's the law, everybody needs to have at least liability insurance, then your license can be suspended. And then now you're in a real spot, because how do you get to work? Obviously, people in that position, in my experience, still drive. They're not supposed to, but their license gets suspended, and then the only way to take care of that is to satisfy the judgment or to file a bankruptcy. What do you think, Dave, what are the requirements for filing a Chapter 7, the pre-filing requirements?
Yeah, before a case can be filed, the individual has to go through certain requirements, and the first of which is they must take a credit counseling session.
What does that consist of?
The credit counseling session is basically a 1-hour session, which could be done on the computer or in person or over the internet. The cost is approximately $15 these days, and it basically runs you through a series of questions about your income, your assets, your liabilities, and gives you some other ideas of how to get out of debt other than filing a bankruptcy.
How long does the class whether or not it's over the internet or in person or over the phone, generally take?
It lasts about an hour, sometimes a little bit longer.
So if you're filing with your spouse, can you both have one certificate, both take it together, or are you required to take it separately?
The couple can take it together, and they each get a separate certificate. So it's one fee, one time frame, and they're both able to file. The second requirement, pre-filing, is that an individual must provide 2 months' worth of paycheck stubs, pay advices, or some other form of payment. So whether it be a paycheck, Social Security, unemployment benefit, rental income, royalties, whatever it is, they have to provide that to the attorney, because the attorney has to give it to the trustee after the case is filed. And the last requirement for Chapter 7 bankruptcy is the person must provide their most recent federal tax return unless they did not have a requirement to file, and then we would do a statement that says they didn't have to file. But that is the 3 requirements: credit counseling, proof of income, and proof of your federal tax return filing before a Chapter 7 bankruptcy case can be filed with the Clerk of the United States Bankruptcy Court.
Well, got a couple questions for you. How about income level? Or actually, step back for just a sec. Right now, we're we're at the end of January here. So taxes are kind of going to be fresh. A lot of people have kind of filed it because they want to get their money if they're getting a refund. And if you have to pay, then, people wait till that time. So what if we're like in this kind of window period of time? I mean, do I have to provide 2012, or do I have to provide 2013 as well, or just the last one I filed?
Well, as far as tax returns, you have to provide the most recent filing. So right now, the old tax return is what's due, because we haven't crossed the April 15th deadline yet. So if you file early, you can provide your most recent that you just filed, or the one that's currently due. But I want to bring up a point you mentioned about the time of filing. Mm-hmm. When people are receiving their tax refund, that's when they have disposable income. That's when they can finally pay off their bankruptcy attorney. You want to be careful, if you're going to be filing, that you don't file with a heavy return forthcoming, because the trustee can intercept that return. You want to make sure that you receive your return, pay your bills, pay your attorney, and spend it on living expenses before you file. You want that liquidated. You don't want that to be arriving after the filing, because it will be intercepted by a savvy trustee.
And then pretty much that's money that's down the tube that could have been used otherwise and still gotten the bankruptcy as well.
Right. It's money that people are relying on, which I think is a little bit ridiculous, because I would rather see you have more money in your pocket every pay period than to allow this interest-free loan to the government, who then pays you back once a year, that you use like some sort of savings account. I don't agree with that. I think you should take what you're entitled to every pay period and not rely on some big tax refund to fuel your spending during this one period of time.
Right, for saving. Well, is there a requirement? I mean, what can I make too much money to file a Chapter 7?
You can make too much money. If you are over the median for your family size and your locality, then you have to submit to a means test. The means test is basically a determination as to whether or not you have the ability to pay back a portion of your debt, or whether you do not have the ability. And if you make over the median, you still might pass the means test, whereby you don't need to do a Chapter 13 and you could eliminate your debt. However, if your income is such that you have the ability to repay a portion of your debt over a 3 to 5 year period, then you're not going to be allowed to get a fresh start, and you're going to be required to do a bill consolidation.
And that was the big change, 6, 7, or 8, I forget how long it's been.
October 17, 2005 is when that law came into place, and it basically wanted to make sure that those who needed a fresh start were granted a fresh start, but those who had the ability to pay didn't get out of their obligation. Those that had the ability were forced to repay something over a 3 to 5 year period. So it's a very fair law going forward. The only unfair part is that the ability to pay is based on IRS guidelines, which don't really measure up to what people actually spend on food, clothing, transportation, and housing. So you have to live within the IRS guidelines to pass that test. But most clients that I see, Jesse, are passing the test without a problem. Let's talk about what's created the minute a bankruptcy case under Chapter 7 is filed. and that's the automatic stay.
Yes.
What is the automatic stay, and how does it benefit a debtor?
It's a really great tool because when you have all of your creditors, and you know, I just want to tell our viewers at home, you can't ignore the problem. If you ignore the problem, it's not going to go away. It's just going to get worse. What you need to do is, as soon as you're in dire financial straits, there is to talk to an experienced bankruptcy attorney to figure out what your options are. It might not be that you might not have to file right then, but at least you'll know, and you're doing something rather than sticking your head in the sand. But what upon the filing, when you file your Chapter 7 with the bankruptcy court, the automatic stay essentially prohibits any creditor from taking any action to collect what you owe them. So once the Chapter 7 is filed, and generally the bankruptcy court sends out generated notices to the creditors, and then they're prohibited from even calling you. Any steps whatsoever. In fact, it's even much worse than that, because I'll tell you, if, for example, you are in a situation where you've started collection proceedings, or let's just say that I've issued whatever it was, as soon as I get that stay, as an attorney, I have an affirmative obligation to take steps to stop it. I cannot simply just do nothing. So the automatic stay is a powerful, actually, it's a powerful shield to prevent the abuses that occur with some of the creditors who will abuse the automatic stay.
Right. I do want to point out that the automatic stay is not absolute with regard to child support,
Right.
Maintenance, domestic support obligations, criminal fines or criminal prosecution doesn't stop based on a bankruptcy filing. So it is
Taxes,
very powerful.
Yep.
But there are some limits on what the stay will do. But for the most part, you're right. Creditors see that stay. It's a big stop sign. They have to stop.
Well, Dave, what debts are typically eliminated with the Chapter 7?
Well, Chapter 7 is going to eliminate typical unsecured debt, such as credit cards, medical bills, personal loans, past due utility bills, auto repossession deficiencies, foreclosure deficiencies. The majority of someone's debt under Chapter 7 is going to be eliminated. Now, there are some exceptions: student loans, recent taxes, parking tickets, child support, maintenance payments, debts incurred by fraud, debts incurred based on DUI driving. If you injure somebody, ironically, you can get out of the debt to the car, but you can't get out of the injury to the person if you're driving DUI. So there's a little bit of a distinction there. It's not the total debt is non-dischargeable, just the injury portion. But for the overwhelming majority of clients or people who I see every day, most of their debt is being eliminated. They're getting a nice fresh start. They're getting to breathe again. They're getting to live their life again like normal citizens without that burden of the creditor always at the door.
I want to talk about a couple of things in terms of, you mentioned past due utility bills. So what happens then if I owe ComEd a chunk of cash, and so now with automatic stay, they're prohibited from collecting the past due amount, and so are they going to unplug me? They're going to turn off my services?
They're not going to turn off your services, but what they're going to do is they're going to wipe out the debt from the date of filing going backwards, and then moving forward, they're either going to continue your service as normal, or more typically, they're going to ask for a security deposit. A security deposit of anywhere from 1.5 to 2 times what a normal bill would have been, and that's to provide adequate assurance that you're going to pay going forward. So the Bankruptcy Code provides for that level of protection for the utility service, but you do eliminate the debt. So for example, someone comes to see me, they've got a $900 ComEd bill. I'm going to tell them to put that ComEd bill in their Chapter 7 bankruptcy filing to eliminate that debt. And the worst case scenario, they're going to be responsible for a 1.5 to 2 times a normal month security deposit. And again, that's their money. So it's going to get refunded if they ever leave that residence, but it assures the utility company that there's going to be money to make a payment. But therefore, service stays uninterrupted.
But after you file a Chapter 7, when can I file a Chapter 7 again?
Well, you can only file a Chapter 7 and receive a discharge every 8 years.
So if I get my discharge, they're good for 8 years. I mean, so I'm not going to be able to discharge everything until 8 years and a day.
Right. Well, hopefully after you file bankruptcy the first time, you're going to change some of the areas where you're running into problems. So, for example, if you were constantly getting medical bills because you didn't have medical insurance, now under the Obama plan, you should be able to get insurance. If you were driving without insurance, hopefully you learn that you can't do that and you have to get the minimum insurance so that you don't get suspended. And also, if you've been crazy purchasing with the credit cards, hopefully you've changed through the counseling and the financial management class that you're going to be better with cash. And in fact, with all these stores, your identity is at risk if you use a card. So you're wise to just use cash basis, which is what you're going to have to do immediately after a bankruptcy case.
I see a lot of folks, unfortunately, repeat. They filed way back when, and now they're back, and it covers all age groups. Younger, older. I mean, they're always in between there. Let me ask you though too, because you said that there were secured and unsecured creditors. So an unsecured creditor would be like the gas company or utility company or credit card bill, right? Okay.
Right.
And then what are secured creditors?
Well, a secured creditor is someone who is secured by property. And what I mean by that, if you don't make a mortgage payment, you can be foreclosed upon. If you don't make an auto payment, your vehicle could be repossessed.
But I can still do a Chapter 7 and get rid of that debt too. Is that correct?
With regard to secured property, you have to make a decision on whether you want to keep that property and continue to pay for it or surrender the property in full satisfaction of the debt. Most people, though, whether it's houses and cars in a Chapter 7, they want to keep those items. They want to get rid of the credit cards, the medical bills, and the personal loans and the utility bills, but they want to keep their house, which they're up to date on usually, and they want to keep their car, which they need to get to work.
I think we've touched a little bit on this, but what typically then are the types of debts that are not dischargeable? I think you hit on a couple of them, student loans and some other things there too. So.
The big non-dischargeable debts are student loans, recent taxes, parking tickets, child support, maintenance payments, debts owed to a municipality in the way of a fine or a fee, and then, of course, debts incurred by fraud. I want to talk about this briefly, too. A lot of people have credit card debt, and they get this great idea, they think, that if they're going to file for bankruptcy, they're going to max out those cards, take it to the limit, and then go see a bankruptcy attorney and file. Well, the credit card companies are very smart. They know when you filed. They know when you made your last purchase. They know where, how much, and for what type of service. If you run up the card or take a huge cash advance in anticipation of filing, that credit card merchant can bring an adversarial complaint to hold recent charges non-dischargeable. And that means you're going to owe that going forward, even after you do your bankruptcy. So be very careful about using your credit card for any major purchases, any non-necessity, basically, too close to filing a bankruptcy.
I find that a lot of folks are just simply using the credit card to live. I mean, they're paying, they're buying groceries or buying the things that they need, and then they're transferring a balance to another card, and they've been doing this for the past, several years here to keep afloat.
Well, the whole thing with the credit cards, in my opinion, is a racket. They've gotten people so addicted to the points involved and the perks involved with these cards that people are using it for everything, where in the past they didn't use it for everything. They're swiping the card at McDonald's, at the gas station, at the grocery store, everywhere they buy anything. And what they're doing is they're overspending. Studies show that when you don't use plastic and you actually have to pull cash out of your pocket, you pay a lot less or purchase a lot less. And these perks, Jesse, they're not so great. The 1% back, the airline flight, they can do without those. They'd be better off spending less using cash. And that's what a lot of clients have to do after they get a fresh start.
Oh, I'm a fan of the airline tickets or airline points. You're going to spend it anyway. And, well, that's, I suppose, for responsible people that are actually going to pay off what you charge on a monthly basis. If you use it that way, you use it wisely. And so you're using somebody else's money for free. Plus, you get those other things. But, you have to be disciplined in order to be able to do that. I want to mention one thing when you're talking about government fines and stuff like that, because this is something that is just amazing to me. I've had people that have come in with IPAS. IPAS violations, by the way, are government fines, so those are not dischargeable. And you have to negotiate whatever reduction you do with with them. I've had people that have come in with $40,000, $50,000 in IPAS violations, and I'm racking my brain. I can understand a little bit. You might have missed a couple, okay. And what happens is it gets compounded with interest, with penalties, and it keeps on going up and up. But obviously you know whether or not you have an IPAS. And so you continue to do these things. It just is pretty incredible to me. So, grab an IPAS or throw the change into the bin there. Believe me, you're going to be a whole lot better off if you do that.
Well, if you're someone who's having a hard time getting by and you're living paycheck to paycheck and you see an open lane on the highway that doesn't have a gate, some people are going to take that door and they're going to go through it. Yeah, and that's what happens.
But you got to know that if it's tollway. Okay, I mean that's all I'm telling you. Just avoid a headache for yourself. That's all.
I agree.
So, what happens then after you file? First, how long does it take from the time that you file your petition for Chapter 7 to the time that you get discharged? Generally, about how long is that?
Well, a typical case is going to last anywhere from 3 to 4 months from start to finish, depending on the timing of the court system.
So 90 to 120 days.
Yeah, basically once a case is filed, the clerk of the U.S. Bankruptcy Court is going to send out a notice of a meeting of creditors. This is known as kind of the court date where someone has to appear before a trustee. That takes place approximately 4 to 6 weeks after a case is filed. And then after that meeting, there's about a 60-day waiting period where creditors can file objections or complaints to the discharge. So once that waiting period is over and you've fulfilled all of your requirements, the clerk of the bankruptcy court is then going to issue a discharge order, which is a one-page document that says your case has gone through to completion and that no creditors can bother you on those discharged debts again.
But those are only the debts that are actually dischargeable. So if you owe me child support, I don't have to do anything specifically because it's not dischargeable as a matter of course.
Right. Certain debts are non-dischargeable per se. Other debts are in a gray area where a creditor will have to bring an adversarial complaint, such as a credit card company who feels that the purchases were made in contemplation of bankruptcy and thus fraudulent.
Does it happen quite often?
It happens about 2% of the time. It really depends upon the client and whether the client listens to the advice that I give. When someone comes to see me for the first time, I advise them, do not use your credit cards again. Some clients listen, some go out and max it out anyway, thinking they'll get away with it. They often do not. So let's talk about the one court date that happens 4 to 6 weeks after the case is filed. This is known as the meeting of creditors under Section 341 of the Bankruptcy Code. Mm-hmm. What happens at that meeting, Jesse?
Well, generally, you're in a room with the bankruptcy trustee, the attorney, and yourself, or you and your spouse if you're doing a joint. And believe it or not, and this always tickles me, they record these with a little cassette recorder. Baffles my mind why they wouldn't go digital, but it's okay. It tickles me because I think you'd be hard pressed to find a recorder to play something or to tape them. So essentially, the trustee is going to ask a few questions, and your attorney should really prepare you for it. Realistically, when you get up there before the trustee and you're sitting down there, it's kind of informal-ish, and probably takes about 5 minutes, provided there are no issues. The bankruptcy trustee is going to ask for your driver's license, social security card to make sure that that's yours. He's going to ask, or she's going to ask, whether or not you've read the petition before you have signed it, and what your fee agreement is with your attorney, and those are all papers that are attached with your petition. They're going to ask you questions like whether or not anybody owes you any money, whether or not you have a cause of action against somebody. Maybe I was in a car accident and I could sue this person for money. They want to know about all those things. Whether or not I have transferred any assets, any money, any property within the past few years here. Those are the kind of things that the trustee is going to kind of look at. And those are basically the questions he's going to ask. After he asks those questions and you answer those questions, that's generally about it, and the meeting of creditors is concluded.
Why is the trustee engaging in a search for assets?
Well, it's his job as the trustee. Everything, once you file the Chapter 7, now those assets belong really to the trustee. They're held in trust. They don't really belong to the trustee, but because you're availing yourself of the bankruptcy court for protection, they're going to look to make sure, and I think you alluded to that earlier, if you have something, if you have assets to pay a creditor, all right, that go beyond the exemption that we'll talk about in a moment, then you're going to pay that creditor back. I can't expect that I'm going to discharge all my debts, but I still get to keep this pot of money that I have in the bank, okay? So it doesn't work that way, because that wouldn't be fair. If I've got, $100,000 in my bank account and I still want to do a bankruptcy, not so much. So he's just looking, he's doing his due diligence, essentially, is what that is.
Okay. Well, Chapter 7 is basically, we know it as a fresh start.
Right.
It's known as fresh start bankruptcy, but it's actually called liquidation under the bankruptcy code. So what I like to tell my clients is it's pretty much you're putting all of your belongings, whatever you own, you're putting it in a box. You're bringing that box before the trustee. You're laying it all out there and saying, this is what I have. I need to liquidate this. I need a fresh start. But in reality, Illinois law allows you to protect a lot of those items, if not all of them, while you're going through the bankruptcy. So the trustee has to see what you have. You're throwing it all out there. You're not hiding anything. You're then saying Illinois law allows me to keep all this stuff, so I'm going to take it back with me, and I'm going to eliminate the people on my petition and schedule, such as Discover, MasterCard, American Express, and any other medical bill and any other unsecured debt. So you are technically liquidating your bankruptcy estate, but in many cases there's nothing to liquidate because it's all protectable under Illinois law.
Well,
and that's a beautiful thing.
Some people have bigger boxes, Dave, and some people have smaller ones. So what property then can I continue to keep in a Chapter 7 bankruptcy? Well, talk about a house. A lot of people have, a lot of people, and this is what I find, because their home is their home, and people are really, really attached to their homes, especially if they have family and they have, smaller children, especially in those circumstances. But a lot of times, they've made certain that they've paid their mortgage, and they're up to date on it. They're not behind on it.
Right.
It's just everything else.
Well, remember, a house is not a home without love, Jesse.
Oh boy, that's really good, Dave.
Yeah.
So there are some houses out there, but not necessarily homes.
All right. Under Illinois law, getting back to the business here, you're allowed to protect as an individual up to $15,000 worth of equity in real estate. So if you're filing husband and wife, you can protect up to $30,000. And in reality, you can protect a little bit more than that, because the trustee would have to sell the property, liquidate it, pay you your exemption, and there's costs involved in that.
So I get, if I'm over the exemption and they sell it, then I'm going to get it.
Right.
My money back.
As far as a vehicle, you're entitled to a $2,400 exemption in one motor vehicle.
Just one?
Just one. Husband and wife case with one car, you can double that to $4,800.
Okay, so 24 for your car and 24 for my car. That's how that would work. Okay.
And very importantly, there's a $4,000 wild card exemption that you can use to cover any kind of personal property. So in a joint case, husband and wife, we're talking about $8,000.
So my personal belongings in the house, my clothes, cufflinks.
Your bank accounts, you can put it on your car. You just can't put it on real estate, because real estate is not personal, it's real property. So
Let me ask you one thing that I think is really important, because people, they think that bankruptcy is the kiss of death, and it really isn't. It's really breathes in new life, is what that does, and again, gives you the fresh start. Am I dead in the water if I file a bankruptcy? Will I ever get credit again? Will I ever get a credit card? Will I ever be able to buy a house?
yes, you will be, and we'll deal with that on another show. Jesse, thanks for joining me
You
today.
bet, Dave.
It's been Legal Action. My name is David Siegel. We'll see you next time. Take care.